right, hi, and welcome back again. Attorney Steve Vondran. So say you have a YouTube channel or you run a Facebook fan page and you post something on your page, a video maybe a video with a picture in it, maybe a video with somebody else's video in it, maybe a video with a quote in it. Okay, what happens if somebody takes down your video and you say, what? This is fair use. I'm commenting on the photo. I'm criticizing the photo and I get a takedown and a strike. Maybe that's your third strike. Maybe it terminates your account, causing severe damages. Okay, so you're monetizing your account. What do you do? Without further ado, let's head to the Attorney Steve litigation whiteboard and let's find out here. Okay, all right. So we are here talking today about the copyright law. This is the DMCA. Stands for Digital Millennium Copyright Act. Digital Millennium Copyright Act. Very important law. And in particular, we're talking about 17 USC, Title 17, USC 512F as in Frankfurter. F as in Frankfurter. So this is a section that allows for lawsuits to be filed if somebody is issuing these takedown notices in bad faith. Okay, this is what we call the DMCA 512F bad faith action. Okay, because a lot of people will call me and they'll say, what's my recourse if somebody's taking things down and just bullying me and doing all this? And, you know, YouTube's giving me strikes and they're trying to monetize my videos. They're trying to take my channel down. Maybe it's a competitor trying to take your channel down for some reason. This law was designed to stop the abuses in the DMCA law, to stop the abuses, okay? So here you are. Here's my handy picture. You know I love my pictures here, right? So here's you. Here's your fair use. And somebody over here, the copyright holder, okay, the copyright holder or the alleged copyright holder, make sure they actually have the rights. Sometimes they're a partner, sometimes they think they have the rights and they don't. But here's your copyright holder issues. They see your picture or your quote. Maybe it's somebody, a picture of somebody and they think it violates their rights of publicity in California, okay? They issue the takedown letter. YouTube, your service provider, they have safe harbors, so they're good as long as they're taking things down. You can't sue them. Okay, they have what's called DMCA safe harbors as long as they have a registered agent. Okay, and usually they do, not always. Look for that. But so you got your video, they're taking it down. You say, what the heck? That's fair use. I have watched Attorney Steve's videos. He has talked about fair use, and I know what it is. It's a 4-factor test, and some things are built right in. Comment, criticism, scholarly purposes, research purposes, educational purposes. Those things are built into Section 107 of the statute. They can't just go take this down. So what do you do? What do you do? Well, you may have to go through the counter notification process. You may have to seek a retraction from them, and sometimes you may have to cite and quote the law, the 512F as litigation counsel. Sometimes in intellectual property area, we have to send a letter advising them that what you're doing is in excess of what the law allows, and specifically, you could be violating and exposing yourselves to legal risk, legal liability by sending a bad faith DMCA takedown notice, okay? So that's what it is. And, you know, I want to tell you some of the particulars, though. The 512F law, there is not a whole lot of case law on this, which is why I think it's important that you understand. But some of the cases that are out there, and I'm going to post them on my blog, my DMC Bad Faith, go to attorneysteve.com and type in DMCA into the search bar. You'll probably find my cases. But I'm going to post 2 cases. The big one that I'm going to post is the Lentz versus Universal. This is out of the Northern District of California. This is a case where the plaintiff for Prince, this was the dancing video, the kid that was doing the dancing video, and it was fun. It was a transformative use of his copyright. He didn't like it. They sued. In this case ensued, and there was a 512F claim brought in that case, 512F, saying this is bad faith takedown. What, kid having fun, dancing around? Come on, really? So, but the case talked about it, overcame a motion to dismiss on 512F. The key thing to realize in these cases is you're going to have to, let me get my pen out. you're going to have to show bad faith. And when I say bad faith, in law, if you follow my videos, there's a difference between objective and subjective. Do you know the difference? Objective means like the reasonable person, what the reasonable person would do. And we can debate what a reasonable person is. And if you go to law school, that is what you'll debate. What should the reasonable person do? But in this law, particular law, you need, oh, we got a call already. Hang on, let's see here. What do you need? They did what? Oh, that's crazy. Just kidding. Just kidding. So, so you need subjective bad faith. Subjective bad faith. Okay, that means you have to show that they knew, knowing in material, misrepresentation, mistake, or misidentification, that it was knowing in material. Now, that's not always easy to do, because how can you really get inside somebody's mind? And moreover, if you ask somebody the question, did you do this on purpose, knowing it was bad faith? Me? No. Why would I do that? I would never do that. So getting someone to admit it can be very, very difficult. But that's stuff that you can find out in discovery when you get into discovery, okay? But to get past the pleading stage, you've got to be able to meet the strict pleading standards. You have to be able to articulate how they knew what this. Now, one way may be to say, well, they're represented by Copyright Counsel. This is a big company. They have Copyright Counsel, or the Copyright Counsel set the takedown. So we don't know. What does the takedown say? What does the takedown letter say? Do we know? That may be something you have to find out. But alleging that this was a fair use, that it was comment, criticism, scholarly purposes, educational purposes, or it meets the four-factor test. We've talked about this in other videos, the four-factor test. Okay, and I'm not going to go over it here, but to say it's not a commercial use, you only used a little snippet. They're going crazy for no reason. It's not a market substitute. There's nothing to get bent out of shape about. So if you can show that, and it was obvious, like facially violates fair use in Section 107, cites the fair use law. Facially, it violates the fair use. Laying out the factors, the four factors, these are the things you're going to want to do to get over these motion to dismiss. What else do I have up here? No proper consideration of fair use. This is what you may want to be looking at, is under this Lentz law is, you do need to consider, if you're sending this takedown notice, you do need to consider fair use rights. And I think it's a good practice. Otherwise, this is a federal law. You could open yourself up into a bad faith case in your jurisdiction. Okay, every circuit's going to have its different case law. This is Ninth Circuit we're talking about, case from the Northern District of California, but it could be anywhere. It could be New York, Texas, anywhere, okay? So strict pleadings, making sure that you're putting out enough to get past that motion to dismiss, that's the key. Counters and retractions, as I said, you may want to do a counter notification. A lot of times we can get strikes to go away. We've got channels put back up. Seeking retractions, okay, this is key. Now, I have found that YouTube is not the easiest to deal with. Why? Because they're putting up like 1 billion videos a day. Like, they really don't have time for like one tiny account. So seeking retraction is what they rely on big time. Big time. If you can get the other party to retract, explain to them that maybe it was fair use, explain to them that, look, there is a law called the bad faith abuse. We don't want to have to go there, but I mean, come on. Fair use is a legal right under Section 107. Now, finally, two more things. You have the damages. Now, you do need to allege some type of damages. Now, you may say, well, geez, somebody just takes down my video. What kind of damages does that cost? Could cost you monetization, especially if you have a popular channel. Cost you monetization. It could cost you free speech. You may say, well, this is totally you infringed on my free speech rights. You chilled my free speech. That may be a form of damages that a court may accept. You may try attorney fees. We were forced to pay fees or to do this and combat that. So be thinking about that. That's part of your pleading. That's part of your pleading stage right there. You want to make sure you're pleading these elements right here. Very important, because you got to get over the motion to dismiss. Then you have to prove your case through a discovery so you're not subject to a motion for summary judgment. And keep in mind your statute of limitations. Okay, that's the end result of how long you can bring it. So that's your DMCA bad faith law. That answers the question, what do I do if somebody's taking my stuff down off of Facebook or YouTube or Twitter in bad faith? What do I do? There you have it. Attorney Steve, litigation whiteboard. One more time. Litigation whiteboard, bringing you the breaking stuff that you need to know. You now know more than most people will ever know about DMCA bad faith law. If you need help, you know where to find us. Copyright infringement on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. I got to run. Hope you all are having a fantastic day. Just knocking out the 2020. We're off to a great start. It's a great new year. It's a great year to get your goals done, make your dreams happen. Okay.